Welcome to part 2 and a tad more Penelope. So we talked about Bernard Goetz and we talked about the reasonable person standard. What we see is people's perception of crime changing from the original crime in the criminal matter to 1996 when it was a civil matter. So we get into this issue that, well, it appears that we're allowing defendants off the hook because they weren't Mirandized, because the search warrant was improperly filled out, and sometimes it was that minor, right? Is it warranted to allow people who are clearly guilty, or is it warranted to have their evidence suppressed to essentially let them go, even if they're clearly guilty, just because there was some technical mistake made in a warrant or some other document? Is it worth him to let him go, right, because of this flawed? Now, hindsight bias says no, but we know that hindsight bias is kind of a horrible psychological phenomenon. Everyone knows with great accuracy after the fact, right? And we can support that in the lab because it's an easy lab experiment to do. You ask people before something happens, what's the probability of this happening? And they give you a relatively low probability, and then you make it happen and you say, hey, what would you have predicted the probability of this was happening? And people always raise their assessment of probability based on that hindsight, and that's why we call it a bias, because it's a cognitive mechanism. Right? So police inappropriateness linked to whether they found anything or not. And this is another perceptual issue. Do we believe the police acted inappropriately? Well, if they conducted a search and they didn't find anything, we say, yeah, they shouldn't have done that. But if the police conduct an illegal search and then they find something, we say, well, yeah, that's probably okay. And again, that's kind of a perfect representation of the hindsight bias. So, exclusion then is excluding evidence from the court and from the jury seeing it, right? So as we see the crime control model ascend, that is, due process is now on the wane. We're coming out of the 70s into the 90s, and we're going to start challenging a lot of these early 60s due process decisions. For example, good faith. In United States versus Leon, a warrant's okay even if probable cause on which it was based was flawed. So the police present the judge probable cause, and the probable cause then fell apart. It really didn't support the issuing of the warrant, but the warrant was issued. Then they come back and say, well, even if the probable cause is flawed, the warrant should probably still stand, right? Because they were operating in good faith. And this often was informants told the police, hey, yeah, this guy's got this in that house, right? And the police go to the judge with the informant's testimony and say, yeah, we need a warrant, right? And the informant was lying. Well, the police believe the informant, so that's the good faith. So we're probably going to allow the evidence then and not have it as an exception to exclusion. Another issue is standing. We must have legitimate expectations of privacy in the place or thing being searched, right? And the U.S. versus Painter was convicted on the basis of evidence taken from a banker's briefcase. Painter said, hey, you cannot use that evidence because you took it illegally from my banker's briefcase. And the courts came back, and this is interesting. They say, well, Painter, that's not your briefcase, is it? And he goes, no, that's the banker's briefcase. And he says, well, then you have no control of the banker's briefcase. You really can't say anything about it. In other words, you don't have standing. It was taken from the banker. It was not taken from you. We will allow the evidence to be used in court. Right? And that's a pretty shady deal. And remember, at this point in time, all bank records are fair game. So if you think you have privacy in that regard, you don't. And don't assume you do. Inevitable discovery. If it can be reasonably demonstrated the evidence would have been discovered anyway, then it really doesn't matter if it was illegally obtained in the first place. And the case that kind of centered where this occurred was Nix versus Williams. Williams was convicted of the 10-year-old girl because a 10-year-old girl that he murdered would have been found anyway. And the police kind of coerced the location of the body out of Williams. The police had promised when they were transporting Williams that they wouldn't talk to him about the case while they were transporting him, and that let the attorney off the hook that he didn't need to drive with them to protect Williams. But they did in fact wear Williams down in the car. Williams eventually said her body is out in this field, and lo and behold, He took him there. The police found the body, charged him with the murder, and used the body as evidence. The police's argument when there was a motion to suppress the evidence was, look, we were searching these areas. We were doing a countywide search, and they produced search grids that showed on schedule which fields they would be searching when. They were going to be there anyway. So at this point, the court said, we're not going to throw that out as evidence because it would have been discovered. That is inevitable discovery. So what we see then is we have a bunch of protections for due process, right? But over time, as the perception that crime is increasing, then courts slowly erode those protections on a case-by-case basis. Right? So now let's talk about Fourth Amendment a little bit, because it's pertinent to an awful lot of folks. What is not private? Well, what is not private? Places that aren't private, your bank records, so forget about it, right? Backyards, open lots, so your backyard is fair game. If the police want to come in and check it out, they will. Garbage on the curb. So if you put your garbage out in a public space, then police can go through your garbage, right? Now if the garbage is protected in your home, not so much, but out on the curtilage. And remember, curtilage is part of the property that you own, but the city has a right to. So often, if you have a sidewalk and then you have a little grass on the other side of the sidewalk that you have to maintain, that's curtilage. That's fair game out there, right? Fenced fields. Okay, you may have a fence around it, but that doesn't mean that the police can't go in there and obtain evidence. Right? No warrant needed to search, just probable cause. That is, I have the reasonable suspicion is usually how probable cause is defined for cars. Cars are a tough one though. Don't take that. It's a very complicated issue with cars. Is the trunk okay? There's plain sight rules. What about the glove compartment? It's a messed up area, and it's on a state-by-state basis. All right. So, in some states it's illegal to have a hidden compartment in your trunk. Yeah, no kidding. So, planes. Obviously, there is no privacy on planes. Just forget about it. That first pertain to private planes, but let's take it for all planes. Now, buses are a problematic one. Right after 9/11, within a year after 9/11, 2 years, right, the TSA was becoming all-powerful. Down at Broad and High, for example, a main bus stop, occasionally TSA was showing up at Broad and High, and those of us who were going to get on Dakota, right, to come to school or whatever, the police and the TSA agent would be like there, and they'd say, hey, we'd like to look through your backpack. And it's like, hey, go jump off a cliff, right? You have no right to look at my backpack because I'm getting on a bus. Going to school is not probable cause to search my backpack. So they need something more substantial than that, right? And a lot of people were just telling the cops to go pound salt. Notice that they don't do that anymore. It was kind of TSA overreach at that point in time. Now, homes shared with others or owned by landlord. Big warning for you guys. If you have a rental, don't expect any privacy legally. If the landlord says go ahead and search, they're going to go ahead and search, right, and probably get away with it. If your roommate says, yeah, it's okay if you look at their stuff, it's probably okay. So if you live with others, if you live in a rental property, do not have an expectation of privacy. You're just safer that way, if you see what I mean, right? When police have a reasonable suspicion of criminal activity like a DUI, then evidence they collect is probably not going to be excluded. Now, what is reasonable might be debated within the context of the courtroom. Okay? So, what else doesn't appear to be private? You can go to this link here if you want. This is kind of an egregious offense, and I don't know how this is going to shape up. But there's been times, let's say, in this case, this cavity search, that is, the police suspected that they pulled a driver over. They suspected that the driver had engaged in a drug purchase. They look for the drugs and they can't find them. They can't find them in the car, and they can't find them patting the person down. So what do? They say, well, obviously the person bought the drugs and they secreted them up their rectum. So Now they take the person, they might do a digital search on the side of the road, which is super egregious, or take them to the hospital and have nurses and doctors probe the anus, maybe x-ray the stomach, etc., to look for the contraband, to look for the illegal substances. This one is really problematic. This particular example is multiple cavity searches, etc., and was constituted illegal search. But it's hard to know, right? So it's an unfortunate situation that sometimes people become so overwhelmed with their desire to demonstrate criminal behavior that they stop operating on the basis of the law and start engaging in illegal search activities as if they were allowed to. And this is one of the reasons that attorneys are so important to us and why the wealthy have an advantage, because you can lawyer up, right? And the threat that the wealthy pose to the police officers, the police might be less likely to take a gamble on these kinds of illegal searches when someone appears wealthy, because they know they will lawyer up and cause the police pain as a result of their illegal activity. Anyway, the factors to consider, according to the Supreme Court, if you want a kind of a big picture look on this, is the scope of the intrusion. And anal exams, vaginal exams, right, the scope of the intrusion is severe and probably less warranted. The manner in which the search is conducted, right, doing this on the roadside is not going to cut it. Taking someone to a hospital might be found to be more acceptable. Ultimately, though, what was the justification for the search in the first place? And the place where the search is conducted matters as well. Now, we can shift gears here and kind of look at it psychologically. What do people consider private versus not private? So in these studies, we're going to look at people's perceptions about search and seizure issues. So Slobodan and Schumacher, subjects read about a bunch of evidence seizure situations. So they come in and they read these made-up situations. Half read the scenarios as if it happened to them, and half are told to read it as if it happened to someone else. So that's one of the independent variables that was manipulated. Half read then, and we further, add in these additional manipulations, half read that the police were looking for something specific, half read that there was no specific search goal. What do we find? Well, if we look at classic court cases and then we look at participant perceptions, now we can assess where the courts and the participants agreed or disagreed. So, in what domains did the participants, the research participants, agree and the courts agree? Okay, surgery, phone bugging, etc. are considered intrusive, that is, outside the law. Flying over backyards, going through garbage, both groups kind of considered not intrusive but acceptable. Now, where the subjects and the courts disagreed then, urine samples, blood tests, searching luggage on a bus, right? Courts are in favor, participants not so much, right? Undercover police posing as secretaries or chauffeurs, that's an interesting one. Think about it. If police want to investigate someone and they're hiring a chauffeur, the police will go undercover and pretend to be a chauffeur, right? Or get a job as a secretary in an office to collect information. And let us dispel one old rumor here. Hear it every semester. I'm not here to hear it from you guys, but I'll just repeat it then. Is people say, well, if you ask a police officer if they're a police officer, they have to tell you the truth, that they're a police officer. And no, that's a fallacy, right? Police officers who go undercover, you can ask them 82 times if they're a police officer and they're going to say no. Are you kidding? Right? There's no requirement that they have to tell you that they're a police officer if they're undercover. So don't fall prey to that rumor, right? Now, subjects also thought searches were generally less intrusive if it happened to someone else and it not happened to them. So whether this is the actor-observer effect playing out or however you want to look at that, right? Hey, if it happens to me, it's frickin' intrusive. Oh, it happened to Joe over there, not so intrusive, right? Probably not surprising. Yeah. So, now, apartment roommate privacy. Courts assume we don't expect privacy when living with a roommate or renting from a landlord. So we have no real honest-to-God expectation of privacy under those circumstances. Kagehiro et al. Did a study. Subjects read one of three scenarios when a third party consented to the search. So this is as if a roommate, said that, yeah, go ahead and search when everyone. Now, the way they vary this, the third party consented to the search, but what's the actual manipulation of the study, the differences? Well, in one case, suspect was present and objecting, saying, no, you can't search, and the roommate saying, ah, yeah, go ahead, right? When the suspect happened to be absent, that is, they were not there, and the roommate said, yeah, go ahead and search. Or the roommate is saying, yeah, go ahead and search. The participant, the subject says, no, don't search, but then the subject has to leave, and then the police search subsequent to that, right? What do we find? The results. And here we enact our favorite word. What are the results, Penelope? It depends, right? That's right, it depends. So if no evidence was ever found in the search, subjects thought it was unreasonable invasion of privacy, and this, of course, goes back to what we were saying earlier, hindsight bias at work. If evidence was actually found, now, but the suspect was present and objecting, subjects thought the third party shouldn't have consented. That is, why is the third party saying search when the actual person is saying, no, leave my shit alone, right? If the suspect was absent, though, then subjects thought it was okay. And again, we have to consider, though, they probably didn't want it to happen, but they're absent, so they're not able there to voice their ideas. So we can see that it's how we perceive this is really kind of context dependent, but that shouldn't surprise us. Anyone, we're pretty good at assessing situational variables. So let's pick on Miranda for a while. Miranda's weakening. You have the right to remain silent. Anything you say can and will be used against you in a court of law. If you need an attorney and you cannot afford one, one will be appointed to you. Do you understand these rights as I've read them to you? It's a weak paraphrase, but kind of close, right? So, how has it been weakened over the years? Because remember, Miranda was what, 66? So we've got almost 40-some years of Miranda under our belt. Well, the confession can be used to impeach one's testimony even if obtained in violation of Miranda rights. So if one testifies, then that confession that's been suppressed can come back to haunt us, so to speak. Now, a couple other debatable points about Miranda. Well, to what extent does someone have to understand their Miranda rights to waive them? Let's suppose we're talking about someone who's mentally challenged, or let's talk about a language issue, or let's talk about a juvenile, or someone who can't necessarily process the consequences of speaking. We used to say, well, they didn't understand the Miranda rights, so it's meaningless. Well, now it's been weakened. That's going to be taken on a case-by-case basis, but a full understanding is not required. Your request for a lawyer. I am not going to speak. I must have a lawyer. Has to be unequivocal. If you do not, firmly come down, assertively say, I am not talking. I must have a lawyer. Then the police are welcome to continue to work on you to get you to speak. Right? This non-custodial loophole is problematic to assess. If the police take you into custody, you must be Mirandized. But what if you're not in custody? And what does that mean? What if you're detained but you're not in custody? Is being detained different than being in custody? If you're walking down the street, right, you're walking down High Street and the police grab you, and they grab you by the arm and they say, hey, we want to ask you some questions. Are they required to Mirandize you at that point in time? And the general gist of it is no, because you're not in custody, right? But you're being detained because the police officers grabbed you by the arm and said they want to speak to you. So notice this is a super gray area. And one thing to protect oneself then is, it's fair game. You can ask the question, well, am I in custody? Because you want to know if you're in custody or if you're not in custody. If you're not in custody, then you don't have to answer any questions, right? But the police don't have to Mirandize you. But if you are in custody, then they do have to Mirandize you, and you still don't have to answer any questions. So that's the custodial loophole, right? Voluntary confessions don't apply, so if someone just starts spilling it, they're good to go. Police don't have to say anything beyond the Miranda warning. That's all they have to communicate. And police lying, as we said earlier in the course, police can lie about anything basically they want to lie about to effect an arrest, but they may not lie about Miranda. So it's the one thing police can't lie about. You do have the right to remain silent, right? And they can't lie about that. Now, under public safety considerations, Mirandizing doesn't necessarily have to occur. For example, if there's an armed robbery in a grocery store, right, and the suspects are trapped inside the grocery store, the police eventually capture the suspects in the store, but they can't find the gun. Now they can sit there and they can question that person till the cows come home. Where is the gun? Where is the gun? Because it represents a public safety consideration. The store can't reopen with perhaps a hidden gun somewhere in it and have a 3-year-old find that and shoot himself or something else. So in that case, public safety outweighs the requirement to Mirandize the suspect necessarily. Okay? So I'm going to break it here and we'll go to the next part in just a moment.